Thank you. So, good afternoon, everyone. It has been a while since I have done a webinar, so nice to see you all again. So, today, and in honor of Open Access Week, we are going to talk about manuscripts, specifically manuscript versions, how to differentiate. We're going to talk a lot about copyright and also licensing. I get a lot of questions around both of those areas, and I thought it would be really useful for folks if we spend some time talking about it. So, with that, we're going to just jump right into manuscript versioning. So, when you publish a journal article, right, we start with a manuscript. There are multiple iterations of a manuscript that are produced throughout the publishing life cycle, right? So, the first version is your very first draft. Everyone's familiar with that. But where we're going to start today is what is called the submitted manuscript. This is the manuscript version that goes to the publisher upon very first submission to said publisher or journal. This is the version of the manuscript that for us here at NOAA has gone through all of our internal approvals, our FRC policy, any IQA review if necessary, so on and so forth. At this point, no action has been taken by the publisher, so it has not gone through peer review. These are sometimes also referred to as preprints. If you place it on a, say, preprint server, it is a preprint. This is not the version that I need when you are trying to comply with the NOAA PAR plan and you're submitting to the repository. This is not the version that we are permitted to archive. This is just the very first iteration of your manuscript that is sent for peer review. So the next one is the accepted manuscript. So there's a lot of different names for this. I'm going to go over a couple of them. Obviously, accepted manuscript or author accepted manuscript. Sometimes you will see me abbreviate it AAM. Sometimes this is called the post-refereed manuscript. We've thrown that language around a few times. So essentially, what we're trying to get at is this is the version of the manuscript that's been created after peer review by the publisher. So after you've submitted it, this is the version that's created after all of that peer review has been done and revisions have been made. So your peer reviewers ask you to make revisions. There's some changes that are made, even some editorial things may be done. This is the version that we're talking about. But I want to be really clear that this is the version before any of the publisher has added their content. So specifically, we're talking about logos, pagination, even some of the formatting, right? Some journals put it in columns. We don't want that because that is all part of what the publisher can copyright. Formatting, obviously logos or any of those added sort of contents, that's all copyrightable material. It can't have any of that on it. This is the version of the manuscript that you should be uploading to RPTS if you use RPTS after the publication has been accepted by the publisher. You, as an author, still hold all the rights to the version of this manuscript. You and your co-authors hold the rights to this version. Let me say it one more time. You still hold the rights to this version of the manuscript. And this is the version that we refer to when we're talking about green open access. So hopefully everyone saw our emails and we talked a little bit about green, gold, and diamond open access. This is the green open access version. So this is the manuscript that you are going to be sending to the NOAA Institutional Repository. This is the version of your article that we want and that complies with the NOAA PAR plan and the upcoming NAO. So I thought what I would do is give an example because this is the one that we want. We have a few examples linked in the repository. There's a ton of manuscripts in the repository, but I thought it would be helpful to have a visual here. We get questions a lot about, hey, mine still has the line numbers. That is fine. You can absolutely send us that version of the document. So again, this particular version of the manuscript has no watermarks. There's no, proof or anything written over it. All the suggestions from the reviewers have been incorporated into the text. I want to highlight, I understand a lot of folks are not always the primary or corresponding or first author, and that's fine. You still should retain a version of this for yourself, even if you are not the corresponding author and you're not the one who is handling some of those edits or the correspondence between you, the publisher, and the authors. You have a right to this. And frankly, your name is attached to it. As a matter of kind of scientific and research integrity, you are going to be held accountable for the content of this. You should have a copy of this. So I recommend folks always, at this stage, once you know something has been accepted, that you contact whoever the first and or corresponding author is and obtain a copy of this for you and your records. Again, this is the version that we want you to upload to RPTS and or send to the repository. So another version of the manuscript that unfortunately folks send to us a lot is what's called a galley proof. This should look familiar to a lot of folks. It often has big watermarks on it, but this is the version that you will typically see after the accepted manuscript. So again, we've gone through peer review, we've added in the comments, we've sent back the manuscript, the accepted manuscript, and what you will usually get back after that is a galley proof, essentially for you and or your co-authors to kind of finalize the look, feel, layout of the article. So here, right in this example, you can see it has the galley proof watermark. It has comments on there. This is from Bulletin of Marine Science. And essentially it's saying this is what it's generally going to look like on the paper. This version of an article is never permitted to be published or archived elsewhere. This is only for this sort of verification purpose. So don't send this to me. I don't want it. I can't do anything with it. I will send it back to you. It is mostly a verification sort of version of the manuscript. So finally, that leads us to the actual version of record, the final approved full version of your journal article. So here we have something from JGR Oceans. This is the authoritative final version. This is the one where your DOI for your article, it's going to point to this version of the article. It has all the logos. It has, publisher formatting, the full pagination, all of that sort of material on it. You will find a copyright statement on this. Where that copyright statement is can vary depending on the publisher, but it will be on this version of the article. You can deposit a version of record with the repository if you have published open access. And by open access, I mean gold open access. So you've paid the article processing charge and your article is listed as open access with the journal. There are some publishers who are incredibly friendly and allow us to use the version of record even if you don't pay for open access. So an excellent example of this is AMS and AGU. So our friends here at AGU both permit us to use the version of record as opposed to a manuscript version. This is a case by case, journal title by journal title basis. So I can't give you, blanket statements other than AMS and AGU are very friendly. Not every publisher has that. Some titles in Elsevier allow us to do it, some don't. It is a case by case basis, which is why we always ask you to send the accepted manuscript. That version we can always use. If we can use the version of record, we will use that. We will not use the manuscript if the version of record, the VOR, is available for archiving in the repository. So I've taken this, I have borrowed this from an article and I've adapted it a little bit. So I do have this cited on the library's publishing guide. But this is just a handy little diagram to sort of show the points of ownership for these manuscripts for manuscript versions. So you can see across the top, I have the submitted, accepted, the proof, and the version of record. And you can sort of see the process underneath with those arrows. The line in the center is the publisher agreement. And I think we're going to talk a little bit more about these in depth, but the copyright transfer agreement might be a term that most folks are familiar with, publisher agreement, copyright agreement, something like that. That point in time, that sort of agreement is kind of where it delineates what's an author-owned version of a manuscript and when it becomes publisher-owned. And so that's what we have here. The accepted and the submitted and accepted are sort of author-owned. Once we have a copyright transfer agreement or publisher agreement, things sort of move into the publisher's hands. So another thing that we have recently gotten a lot of questions about and are directly related to manuscripts are embargoes. I think most folks are familiar with it, but if not, we'll just start from the basics. Embargoes serve as a mechanism for publishers to restrict access to particular versions of a publication. Usually, this is for a very specific period of time. Um, in the sciences, both social sciences, physical sciences, so on and so forth, that embargo period can range anywhere from 6 months up to 24 or more months. Typically, it's about 12 to 24 months. Um, Recently, and in light of the OSTP memo and those requirements, a number of publishers, who I will not call out right now, have very recently, in the past few months, increased their embargo periods. It used to be 12 months. Most of them have gone up to 24 months. A lot of this is um, sort of like I said, responsive to the OSTP memo, but there has been a shift in the publishing industry to sort of holding on to um, rights and sort of the ability to restrict access on things. So embargoes are typically levied on manuscript versions. However, they can be levied on publisher versions. So there are a few publishers who say after 6 months, you can use the publisher's version as opposed to a manuscript version. So that's still a version of an embargo. But when we talk about them, most of the time we're talking about the embargoes placed. Levied against manuscripts and when you can post those in repositories. Um, the duration and the version impacted are typically written into the copyright transfer agreement. So, in there, in copyright transfer agreements, it will say you can post your manuscript after a 12 or 24-month embargo, or you may use the publisher's version of record after a 5-year embargo, or something of that nature. It's usually baked right into that copyright transfer agreement. There's a couple myths about embargoes that I want to make sure we clear up. So a lot of folks always say to me, "So once that embargo is over, I can just use the publisher's version." Again, not necessarily. It depends on what version of the manuscript the embargo is applied to. So again, that's dictated in your copyright transfer agreement. Again, usually it's the manuscript version that we're talking about. The other thing that we hear a lot is folks will wait to submit their publication to the IR until their embargo period is over. So they will hold their manuscript for that 12 or 24 months and then submit it. You do not have to do that. We impose the embargo for you on your behalf. It is part of our system, it's part of our metadata, and our system, the repository itself, does that automatically. So you do not have to hold on to anything. As soon as your manuscript is accepted by the publisher and you have a publication date, like a formal publication date, you can submit that to the repository. If there is a 12, 24-month embargo, a 6-month embargo, whatever it may be, we will impose that for you. So what you would see in those instances in the repository is you will see just the metadata, not the article, but you'll see the title, your information, your ORCID information, the offices that were associated with that publication, funding info. It will have a link to the publisher's page for the version of record, the one that the publisher makes available. You just won't be able to see that manuscript until the embargo ends. It does look like there is a question. If the manuscript submitted to RPTS or the IR gets a DOI and the published version gets one as well, which DOI gets priority? Excellent question. So, um, the priority DOI should always be to the version of record. And I'm sure some folks are asking, wait, how can a manuscript and the final article of said manuscript have two separate DOIs? There are some preprint servers that will mint a DOI for your manuscript. And then once you have your article published with a publisher, they also mint a DOI. The version of record DOI always takes priority. What we can do is we can link that manuscript or preprint version DOI to the publisher's DOI as well. But we are always going to focus on the version of record DOI. It's a great question, whoever asked that. So with that, I am going to move to talking a little bit about copyright and licensing. So, I think it's important to differentiate between the two. Sometimes these terms get thrown around interchangeably. They are not the same. So, copyright. Copyright is who owns that intellectual property. This is something that exists essentially from the moment of creation. You think of something, you start writing something, you own the copyright to that. It is granted to the creator, aka author, unless you transfer that to someone else. And again, we'll talk about this in more detail, but we're talking like through a copyright transfer agreement, or in some instances, a licensing agreement, not to get too into it. But when we're talking about open access, again, Open Access Week, uh, the copyright for open access publications, so again, that's the intellectual content, right? The intellectual property within that content is retained by the authors and or their contributors. They keep that. Licensing is a little bit different. Licensing grants permissions to use the content, right? And this applies to text, data, the whole nine yards. A license is chosen by the person who holds the copyright. And licensing is essentially enforced in perpetuity unless it is altered, usually through something like either another copyright transfer agreement or, as I mentioned, a licensing agreement. Those legally binding documents can alter who owns the copyright and or who can grant permission for licenses. So when we're talking about open access, again, the author or publisher, whoever holds that copyright, chooses the license for it. Typically in an open access world, we're talking about Creative Commons licenses, which we'll get into that. I want to make a note here, and I'll probably say it 3 or 4 more times. Um, no effective transfer of copyright can be made in the US for US government works. So, we as federal employees do not hold copyright for anything we write as part of our duties for the federal government because they do not fall under copyright protection under US copyright law. They are government works, therefore, they are automatically in the public domain. So, just a reminder, and we'll probably talk about that more again. Like right now, like defining a joint work versus a US government work. So I'm going to flip these and talk about a US government work first, which I should have done on the slide, but we're going to go backwards for a minute. So a government work is a work prepared by an officer or employee of the United States government as part of that person's official duties. That is directly from the Copyright Act. If all authors on a joint work are federal employees, the work is considered a government work. The work, again, we're sort of talking about like a publication. If it is produced under a government contract, so if we contract out someone to write a publication for us, it may fall into this category, but that depends on the terms and conditions of that particular award and or contract. It depends. It gets a little tricky. So, a government work is something that is done by government employees for the government as part of our official duties. A joint work is a work that is prepared by 2 or more people with the intention that their contributions be merged. So, you enter into a partnership with someone to create a journal article. That is a joint work because that was your intention to create something that would be a whole together, right? It's a unitary whole. Authors of a joint work are the co owners of the copyright in that work. So if I write an article with Dave, let's say, Dave and I are co owners of that copyright. Federal employees can author a joint work with other non federal entities, but because not everybody on that is a government employee or a federal employee, it doesn't necessarily make it a government work. So there's a difference between the two. Sometimes a joint work is a government work. Sometimes it is not. It gets a little tricky, I know. So as I said, if I, as a federal employee, write an article all by my lonesome as part of my job, I write something about, publishing at NOAA or managing the repository, something or another, right? And I get that published somewhere. it is in the public domain. What that means is, and what exactly do I mean by public domain? Public domain means content that is not protected under the Copyright Act. So again, I am a government employee. I cannot, I have no copyright to give over to a journal. So therefore, there's no copyright on it. It falls into, you'll hear that term, falls into the public domain. So there's a couple ways something becomes public domain or is listed as public domain. So A, the copyright on the work has expired. So something you'll hear a lot about, like what was one of the big ones most recently, Steamboat Willie, right? The Mickey Mouse Steamboat Willie. That version of Mickey Mouse has fallen into the public domain. The copyright duration for that particular character has expired. If a work doesn't have sufficient originality, I won't get too much into that. If the item isn't in a tangible form, so if it's just an idea, you can't really copyright just an idea. You have to have some sort of tangible form, whether that's a document, a movie, a, a musical composition, something like that. There are instances where if you don't include a proper copyright notice prior to 1989, it falls into the public domain. Again, that gets back into like duration of copyright expiring. Or, as I mentioned, if the work was produced by the US federal government. So there's two sorts of labels that you'll see for this. One is a CC0 license, or you'll see something that says straight public domain. So these are the two things that you see. Again, I want to highlight, just because one author on a joint work is a federal employee does not mean that that whole work is automatically in the public domain. Just a reminder, it will come up multiple times throughout this. So I mentioned a little bit about Creative Commons licenses. What I've done here is I've listed out the main versions or the main types of Creative Commons licenses. And what I've done here is I've listed them from the most permissive and the most open to the least open. So with CC0, again, we just talked about public domain. The next would be a CC BY. What this means is it allows the distribution of that article. You can remix it, make derivatives, adapt it, do a lot of different things with it as long as you attribute it to the original authors. There is something called SA, which means share alike. So if someone were to use an article that was licensed under a CC by SA, what that means is that person could make a derivative of it, but that means they have to also share their derivative version under a CC by SA license. It means you also have to make your work open. CC by NC restricts the use of that material to non-commercial use only. Again, there is a share alike option with a CC by NC. ND means no derivatives or adaptations. So you cannot take a work and make a derivative version of it or derive something different from it and license it. And then there's a CC by NCND, which means you cannot use it for commercial purposes. You cannot do adaptations or derivatives. So it's a very restrictive sort of license, but it does still mean that people can share it, people can download it, read it, all of those things for free, as long as they attribute it appropriately. So the question I get a lot is, what license are we supposed to use? What does NOAA require? Our recommendation is that you always use the most open license available to you. Generally, when it comes to journal articles, you're going to go with the CC BY. As part of the government, and especially as part of the Department of Commerce, we should not be restricting our use for derivatives, but also even to commercial entities. It is part of what we do to move science forward, move industry forward, again, part of commerce to help move the economy forward. So we do not recommend folks restrict by NC or ND. We prefer everyone do a CC BY. Again, preferred. So I'll talk a little bit about copyright transfer agreements. Again, I mentioned this earlier. Each publisher calls these a lot of different things. Sometimes you'll see author agreement, publisher agreement, publishing agreement, copyright agreement, a transfer agreement, all these sorts of different iterations. What this means is that you're transferring the copyright of the article to the publisher. So you, as the copyright owner from the instance, are saying, yes, I'm transferring my copyright ownership to this publisher and giving them the right to do things with it, right? Within these agreements, they lay out what you as the author have rights to, such as your archiving policies. So, can you post your manuscript version into an institutional repository? How long is the embargo period on that? Are you entitled to are you entitled to special circumstances like you can post a version of record on your website, something like that. Those types of rights are laid out in these agreements. The tricky part is these rights vary from publisher to publisher, and they can depend on the licensing in and of itself, right? So if you license something under a CC by NCND, that might change some of the rights you have as an author. Within these copyright transfer agreements, to my knowledge, every publisher has the option to indicate if you are a federal employee. You should always have the ability to indicate that. And if not, you need to contact the publisher and tell them of your employment status. It does make a difference. You do need to notify folks that you are a federal employee. So someone asked, why not use CC0 instead of CC BY for government work and data? Great question. In theory, if it is a government work, it will automatically be in the public domain. So, example, tech memos that you submit to the repository and we mint a DOI for them, the library automatically licenses those under a CC0 in the public domain. We apply that license to them. When it comes to a journal article and you have authors that are not federal employees, you can't we can't dictate that it's a CC0. Most publishers do not even offer that as an option. They offer CC BY as the most open, and then if you've published recently, generally they offer you CC BY or the CC BY NCND. Again, we recommend doing the more open one, the CC BY. But if you are authoring something with a non-federal scientist or researcher, they do still have rights, and can still exert those rights. So we can't automatically apply a public domain just because, again, one author is a federal employee. Maybe the other 10 are with different universities. They could even be with different governments, other governments. International copyright gets very tricky. So that is why we recommend the CC BY overall. If everybody associated with the article is a federal employee, it should automatically fall into the public domain. It's a very good question. I will say this on data. Data licensing can be a little bit different. It depends, but generally, as a rule, NOAA again recommends doing everything under a public domain whenever available, and then CC BY whenever available. There are also other types of licenses for data and software, especially. I don't have that information right in front of me. If folks are interested, please let me know. I'm happy to get that and provide that to folks. There is a whole section in the data management handbook that relates to data licensing as well. Great question. Thank you. I did put together some resources. As always, I just want to remind folks how to submit to the repository. If your office uses RPTS, there's a direct link from RPTS to submit articles, your tech memos, tech reports, a whole 9 yards directly to us. All of this will carry right over to us and we will take care of everything for you. Right now, it is a single submission only. So if you want to submit a batch of things to us, you will have to do that through our form or via email. If you are not on RPTS, or again, you want to submit a batch of things to us, you can use our submission form. It is a Google form. We have made this Google form available to intramural and extramural folks. So if you are a program manager and you have grantees at different universities and they need to submit something to us, they can use the Google form as well. Through the form, you can submit a single item. You can submit batch publications, both journal articles and tech memos, tech reports, historical reports, those sorts of things. This is going to require you to input some metadata for us, though. So be forewarned, you can't just upload a file. There are some fields you will have to fill out. The last way, final way, is you can email us. Simply email the IR team. Again, whether you're within NOAA or external to NOAA, the email is available for everyone. Again, you can do a single item or a batch this way. I will say this, with the email submissions, there is a much longer turnaround time. We do prioritize things based on how they were submitted to us. So if you send us an email with your info, it may take us a little bit longer to get things in. As always, we ask for 2 to 3 weeks to get things into the repository. Unfortunately, we are working with a very large backlog right now, so it may be a little bit longer than that. So please bear with us, but if you submit something and you haven't seen it in that time frame and you wanna check on it, please feel free to contact us. Another thing I'd like to, highlight for folks, very much related to all of this, is the Wiley Read and Publish agreement that the library has entered into. So, what we've done, and just as a refresher, is we've taken a lot of the money that we spend on subscriptions and sort of converted those in a way to help cover publishing costs, cover those article processing charges for NOAA authors. So, this applies to all Wiley journals, gold, and hybrid. And this also includes the society journals managed by Wiley. So, specifically, I'm thinking AGU and the American Fisheries Society. Both of those are eligible for this deal. There are some eligibility requirements that I want to remind folks of. There must be a NOAA federal or contract. So, if you are a federal employee or a contract employee with NOAA and you're a corresponding author, you will be covered. If you are a NOAA federal employee and you co-author an article with one of our cooperative institute researchers and they happen to be the corresponding author, we will also cover those. We also require that the article is a research article. We will not cover editorials. We won't cover career spotlights. Please don't ask us. We will reject that. Those are not things that we are going to pay to make openly available. These need to be research articles. We do have a whole guide on the Wiley deal and sort of open access publishing and things of that nature. So please feel free to contact us with more questions about the Wiley deal. But we do ask that folks please take advantage of it. It's a way for you to get something published open access and not have to have your office cover those fees. We do have 2 other options. I won't spend a ton of time on these, but with PLOS Climate, all APCs for all of NOAA have been covered by the library. I have a link here for guidance on how to submit to PLOS Climate, and all your fees are covered. Again, the similar eligibility requirements to the Wiley deal. You should be a NOAA author, federal employee, so on and so forth. But we will cover anything in PLOS Climate. And then we do have what's called a subscribe to open deal with annual reviews. So, what this means is that we subscribe to annual reviews. And if so many people subscribe to annual reviews and their content, all of that content becomes free and openly available. So there's some pros and cons to this. It depends on how many institutions are subscribing. In theory, if not enough institutions subscribe one year, the content could be pulled back. So there's some pros and cons to this, but there are 2 current titles that we have that are covered under this. Annual Review of Fluid Mechanics and Marine Science are covered under this. So I've also listed here just a bunch of the guides and things that I've mentioned. The Publishing and Scholarly Communications Guide, the Open Access Guide, that's where you can find info on the Wiley deal, the PLOS Climate, and a little bit more about annual reviews as well. And we also have a predatory publishing guide. I've also linked here Cobbles, which is a tool to evaluate journals. It helps you determine if a particular journal may be in violation or practicing some predatory practices. And then I've also put in some contact info here just for the repository team, myself directly, as well as just any general library questions or anything. You can always contact library.reference@noaa.gov. If at any point you have any questions about a copyright transfer agreement or licensing or anything like that, I encourage folks to reach out to us in the library. I think we're here to help you. It can get very tricky. Again, every publisher is different, so how it happened with, say, Elsevier may be very different than how Wiley's going to handle it. So I want folks to know that we are here to help walk you through to the best of our ability. I do work really closely with general counsel too, so if I cannot help you, I know who can.
All right. We did get one question that came in the audience chat when it asks when an article should be submitted for depository.
Sure. So we ask that you submit the articles after they have been accepted by the journal and you have a publication date. So most journals, when you submit to them and they approve the article and they accept the article and you resend back in that accepted manuscript version, they will give you an estimated publication date. Usually, they'll also give you a DOI at that same time. Once you have that information, that's when we want it. Because we want to link to the DOI, the publisher's version, and we do need to know when it's officially published because we cannot make the manuscript available prior to that publication date. So essentially, as soon as you know when it will be published, then you can submit it to us. Good question.
Okay, well, thank you very much, Jen, for presenting today, and thank you everyone for attending. We hope to see you at our next library seminar. Have a good one.